thanks so much to our first panel, and we've got a great set of issues now to take up in our second panel. And our second panel is on a new set of governance themes for the infrastructure layer of the internet. And in the past 2 decades, we've had well-attended conversations like the one that we just had about the network layer, alongside a growing set of controversies that we'll discuss in the next panel at the user-facing application layer, thinking about search engines and social media platforms and video platforms and so forth. But we've also had this growing bunch of companies that sit in the middle of the internet and provide services for user-focused platforms, and upon which many of the user-focused platforms that we use rely on, but many of which are not household names, and many of which have sort of been left out of these policy debates, but increasingly over the last couple of years have been swept in. And I'm really delighted that we get a chance to uncover these issues today and talk about them a little bit more. And we've got a great crew of folks to help us do that. So we've got Addie Robertson, who is a senior reporter at The Verge. We've got Kate Ruane, who is a senior legislative counsel at the American Civil Liberties Union. We've got Hal Singer, who's the managing director of Econ 1. And we have Alissa Starzak, who is the head of public policy at Cloudflare. So here's the agenda for today. I think we're going to focus on 3 topics. First, we're going to talk about when we say the infrastructure layer, what do we mean by that? Who's included in that? How are we defining it? Do we need to have subcategories? Is that a meaningful construct to use at all? 2, we'll talk about the kinds of problems and interventions that we might bring to bear at the infrastructure layer. And then last, we'll turn to the political economy of how infrastructure layer providers fit into the ongoing policy conversations, some of which we already started talking about in the last panel. So for our first topic, what is the infrastructure layer? What are we talking about? I'm delighted to turn it over to Alissa, who has kindly volunteered to give us a topology or a taxonomy, if you will, of the infrastructure layer, what the different kinds of providers are that sit in the infrastructure layer. I'll turn it over to her, and then I'll turn it over to our other panelists to share some of their thoughts and how they come into this space, and then we'll go from there. Alissa, happy to turn it over to you.
Thanks, Blake, and happy to talk about all of this today. I think one of the interesting things about the infrastructure layer is that people don't often know what you're talking about because people don't actually think about how information gets to you across the internet. So most people turn on their phone and they think, hey, how do I get to something? Maybe I search for it on Google. That must be infrastructure. They don't actually, or they know they have a contract with a cable provider or a broadband provider to get access to the internet, but they don't actually think about all the things that happen in between. So Cloudflare, it's useful to sort of put in this context. Cloudflare is a company that most people haven't heard of, but it's very much in the infrastructure world. What we do is we actually make websites faster. We make websites more efficient. And we also protect them from cyber attack for a variety of reasons. And we can talk a little bit about that too. But when we think about infrastructure, there is this whole world of players that sits in those kinds of areas. So if you think about it, when you go online, you usually interact with the application layer. So you interact with a website, a particular website that has content on it. You might, one of those websites might be a social media organization that has its own content on it. It's sort of a platform that actually helps you interact with that content. It might be a search engine that helps you interact with that content, but that's all in the content side of the world. We then think about infrastructure sort of moving down into the stack as somebody who stores the content as well. So then you have things like Amazon Web Services, or you have a bunch of large cloud providers or smaller cloud providers as well, or just maybe your own servers too. And then you have a bunch of other providers similar to Cloudflare. So Cloudflare makes networks around the world more efficient. We're a global network. We have lots of points of presence around the world. What we do is we help keep a local copy of content, so a cached copy of content, not the definitive one, to make it faster when someone tries to get access to it. We also have our network positioned in front of websites so that they can't actually be subject to a variety of different kinds of cyber attacks. But there are also entities that fit into our space that are things like the domain name registrar, the person who sells you the domain name. So Twitter.com, of course, has its own platform, but they had to buy the Twitter.com domain name. So there's the registrar that sells them the domain name, and then there's also the registry that owns the .com part of that and helps actually designate which ones actually sit in what can sit in the .com. And then you have a bunch of other providers as well. So you have other providers on the DNS side, someone who tells you how to find the IP address for a particular domain, for example. That's what, so when you go on, how does it actually find what website you're looking for? There's actually a provider for that. And then, of course, you have the access providers on the very bottom of that that help actually just connect people to the internet overall. And I think the interesting thing that people don't think about in that infrastructure stack is that when you get towards the bottom, all of those providers' decisions, if they make decisions, can impact those further up. So, for example, if you have that, again, going to using Twitter as my example, if you have Twitter.com, if the registry says we don't want Twitter.com to exist anymore as a domain name, they can actually revoke the ability to use Twitter.com. So they can make a decision for the entire platform. And I think what we see as a security provider at Cloudflare is that the challenge is also sometimes if you revoke security services, if somebody is a platform that is for whatever reason generates a lot of interest, you can actually, the revocation of security services can also potentially bring a website down. So as we start thinking about what the world looks like, it's important to understand that there are a variety of different players, each who play a role, and each who, without, you may not actually have access to the internet that you know. So I guess I'll stop with that and can turn it back to you.
No, that's a perfect place to start us. And Alissa, I want to give you a shout at the question I'm going to ask the rest of the panelists to turn to, and you could pass on it if you like. But there have been a number of controversies. So we talked in the first panel about net neutrality. It's like what's the problem with net neutrality? We've got a number of kind of high profile incidents, and we heard some of the panelists kind of going back and forth about whether the problems are more sort of philosophical or ideological, or whether there are real problems that occur that require some kind of intervention. But we've seen some pretty high profile, fracasses erupt over some of the infrastructure layer providers, including Cloudflare has been part of some of those. Do you have a particular one that sticks in your mind that you'd be willing to shed some light on?
Yeah, sure. So Cloudflare is an interesting provider in the space, and actually the space that is not the access providers, so not the ISPs, and not the application layer, is a really interesting one because it's not particularly one, people don't know it very well, and two, there aren't a lot of formal rules that apply to it. So unlike a regulated telco, it doesn't have sort of net neutrality rules, and unlike the application layer where everyone sort of interacts with it, people just don't focus on it the same way. I think one of the interesting things about Cloudflare is that we have a free service. So from a practical standpoint, if you want to protect your website from cyber attack, you can actually go on our site and sign up for Cloudflare service and your website for free, and your website can be protected from cyber attack. The interesting thing about that, of course, is that you end up with a very large number of websites that have signed up for free service. We have more than 25 million websites or other services that are signed up through Cloudflare. And sometimes entities sign up that are ones that people really don't like for very important reasons and for things that actually really matter. And we, in 2017, after the Charlottesville attack, one of the sites that was using our service to prevent cyber attack was the Daily Stormer, which is connected with neo-Nazis, if you folks don't know it. And we got a lot of public pressure to remove services. I think, and we ended up actually removing services, but making sort of a big public statement about it, in part because we wanted people to understand that the kinds of services that we were providing were different. So we were not Facebook, that we were not somebody at the application layer. So we actually talked about it a fair amount, but that was one of the sort of big controversies that we wanted to start actually the conversation that we're having now about what termination of services looks like at the layer that we're at in the infrastructure, and why that shouldn't be the same as the application layer. And I should add actually on that, so when we remove services, it doesn't necessarily take a website down. The website, the content is still available somewhere else. It's technically available for access. The thing that takes that website down is the cyber attack that comes after it, because they're no longer protected from attack. So the interesting thing about all of those people who were sort of advocating that we take action, that they were essentially advocating for us to remove services so that the site itself could be subject to a cyber attack. And our sense at the time, and still, is that that's really not the way moderation or regulation should occur. It shouldn't be sort of a cyber attack in order to do content moderation.
So that's a great theme that we want to pick up later in the discussion, which is that we've got all these little bits of machinery that power these user-facing services that seem sort of unified to the user, but pulling out one of the gears will have this cascading effect of what, and maybe we can argue about this, might amount to sort of gatekeeper power, or the ability to sort of kick someone off the internet. Everyone sort of knows that's going to happen. So maybe we can come back to that. But I want to invite our other panelists in here. And first, since we haven't done formal introductions, just to give folks a chance to say a little bit about their work and what they do. And then I want to ask everybody the same question that I ended with you on, Alissa, which is, what is your favorite example of kind of a fracas or a controversy that's arisen over something that you think is an infrastructure platform? So I'm going to start with Kate, and then I'll turn to Hal, and then go to Addie last. Kate, take it away.
Sure, thanks, Blake. And hi, everyone. I'm Kate Ruane, Senior Legislative Counsel at the American Civil Liberties Union. In my role here, I do First Amendment policy advocacy, and I think that's part of how I come to this discussion, because we do a lot of discussion about content moderation, and most of the time we're thinking about the user-facing platforms. But this discussion, as Alissa talked about earlier, is really about the organizations that are deeper in the stack. And when we talk about them, for the ACLU, our censorship concerns are even greater. They're further magnified, because in those cases, often what you're going to see is when they make censorship decisions, what happens isn't targeted to a particular piece of content or to a particular user. It's not granular. It can result in the censorship of entire websites, entire communities. Groups of websites can be stricken from the internet pretty quickly. And so we have a very strong incentive for trying to build normative principles around neutrality in these particular types for these particular types of companies and these particular types of decisions. And I guess to answer Blake's actual question, I'll grab the low-hanging fruit and say the obvious, most recent, I won't say it's my favorite example, but the deplatforming of Parler by Amazon Web Services. That was a decision to remove access to an entire platform from the internet for a period of time, made by Amazon without any real accountability for the decision, and whether it was defensible or not. My guess is that most of the content on Parler did not relate to January 6th and what happened on that day. And so there were a number of users and people who had not engaged in that at all and were just using Parler for whatever they might have been using it for, that were impacted by that much broader decision made by AWS. And that is something that I think we should all think through and sit with when we're thinking about what censorship looks like at the infrastructure level.
So, Kate, before we move on, if I could ask you to just tease apart a little bit in the Parler example in the way that Alissa did in talking about the Daily Stormer example, what exactly happened there? Because I think AWS is another one of these platforms that everybody uses all the time and doesn't realize it and maybe doesn't even know exists. What happened when AWS made the decision to sort of boot Parler, and how did that manifest in this result that you've described, which is essentially Parler completely getting knocked off the internet?
So I'll be honest and say that I might get this totally wrong. So someone should step in and correct me. But my understanding is that it is a web's hosting service. So it was no longer hosting the content. So what Parler then had to do was go find someone else to host the content. So, Parler didn't Parler's content didn't completely disappear, but they had to go somewhere else to make it available on the internet.
So we had this moment of, Parler wasn't like banned from the internet in the sense that that content couldn't find a home somewhere, but they had architected a service basically to operate using AWS, and basically getting that rug yanked out from them introduced this basically enormous switching costs. And I think in the end, they were able to find another hosting service, but it was something like 30 days later before they actually got everything all spun back up. So that gives us this window into, they effectively got knocked offline for that period. And so even though they could go find a competitor, they were off for that period. All right. So two great examples on the table. Hal, turn it to you.
All right, well, thanks for having me. I guess your first question is what brings me to the conversation. And, I'll say that I've served as an expert in a host of program carriage cases. These are discrimination cases that are brought against vertically integrated cable operators pursuant to the non-discrimination standard, or Section 616 of the Cable Act. And so that's what got me into, the issue of regulation and at least in a completely different arena. But as I learned of cases of self-preferencing by dominant tech platforms, it became very clear to me that, at least as far as the economics were concerned, the issues were very close, if not identical. A dominant platform leveraging its power from the platform into the content space. So I began pushing for the same protections for independent content providers. Now, Alissa asked the right question up at the front. I just want to kind of put a bow in it, which is, should we have the same rules as we move up and down the stack? Of course, that begs the question, what are the rules for the application layer? We don't even have any rules yet. We're completely in a world of laissez-faire. Anything goes right now. But people are starting to propose rules for the application layer. And I think that until we kind of have a handle on what those are, it becomes very difficult to ask whether they should be applied further down the stack. The good news for Alissa is that the rules that I think are coming out would not be able to get it at Cloudflare at all, but they could get it at AWS, and I'll explain why in a bit. When you ask me about the best controversy in the space, Blake, in the infrastructure layer, it's not a controversy yet, but I did see an article that was pretty interesting that spoke about how some folks were getting nervous about how Amazon AWS might be conflicted in its dealings with Netflix. So AWS is providing Netflix web hosting services, but it also is competing against Netflix in the application layer in streaming services. And so you could imagine how that could create a situation in which access could be denied or degraded in an effort to support or prop up an affiliate that is competing against the person you're providing this web service to. Now, I just want to close, if I could. I don't get any calls yet concerning the infrastructure layer, because I just don't think that we have a lot of episodes, at least with regard to discrimination, percolating there yet. But I do get calls all the time from independents, whether they're app providers or merchants, telling me how the platform at the application layer has run them out of town. A health passport app provider tells me that Apple won't allow him onto the platform until he has a government sponsor, but Apple isn't applying the same requirement on its own app. And a video streaming player tells me, how Amazon shows his product bundled with peripherals, but that has the effect of pushing his product down in the search rankings because it appears that the price is high, and they don't appear to be doing the same thing with respect to their own streaming device. So, you know, these folks have no protection, not even an antitrust court. And what I've been peddling is to provide a venue in which they could go seek some protection against this discriminatory conduct.
So Hal, these are great themes, and we'll pick a number of them up. I think one, you've mentioned the role of kind of application layer providers that are also providing infrastructural services, maybe interacting in multiple markets, maybe are vertically integrated, maybe interacting in sort of two-sided markets. You introduced the concept of dominance, which I think we'll come back to a couple of times. And you've given us a couple of examples to wrestle with here as we think about what kind of fits into this classification of the infrastructure layer. I promise we'll come back to all of that, and I also want to come back to Kate's point about the First Amendment as well. I think we'll dwell on that, but I want to invite Addie into the conversation. So Addie, from your perch at the Verge, getting to report on all of these companies, you probably follow and know more about these companies than just about anybody else. What brings you to this conversation, and what are some of your favorite examples in this space?
So yeah, I've been covering, as just part of my job at the Verge for the past decade, the way that infrastructure providers can kind of control access to the things that our readers actually know about and are more likely to care about. And a thing that's been sort of an interesting shift over that last decade is that when I started covering this, a lot of the decisions were things that were related to sort of hacktivism, that there were things like WikiLeaks not being able to process payments, or the Pirate Bay getting kicked off of hosts. And that over, at least, especially since 2016, the conversation has shifted a lot more toward discussions that are a lot more sympathetic to the idea that infrastructure providers should be taking down more content, and that content tends to be around terrorism and far-right extremism, and things that are a lot more really clearly directly harmful to sort of the political situation, particularly in the US. And related to that, like, I want to go back to a sort of different aspect of what Alissa was talking about, the Daily Stormer case, which was not only was Cloudflare involved, but there was this very large push to take this site off of domain registrars. That it was it was sort of a turning point. It was one of the first times that there has been just a really huge concerted effort to make a website not able to exist on the internet. And it's particularly interesting because it works kind of opposite to how a lot of big censorship decisions work, which is not that there was one central platform that was able to throttle the site and take it offline, but that there are actually, it's not really that hard to find a competing registrar or to find a large series of competing registrars, but it's also very easy for public pressure to just get you knocked off of those registrars one after the other. And so there was this very interesting weeks or even months long process of this kind of heckler's veto that didn't involve a single big powerful platform. And that I think that's something that often gets overlooked in the discussion over online infrastructure.
So I hear that theme coming back a lot here of these, you know, we're used to thinking about really big, really dominant players, and we've got instead these sort of smaller kind of interconnected cogs. But it sounds like, and maybe this is a theme we want to come back to, that public pressure can shift actions at some of these platforms in a way that perhaps would be more difficult if we were talking about an internet service provider on the low end of the stack, or if we were talking about one of the biggest platforms on the sort of application layer of the stack. Okay, we've got a lot to chew on here. One thing I want to do before we move on from what the sort of question of what is infrastructure, what exactly are we talking about here, is and I think this classification question is important. I'm a telecom law professor, and so we always do these questions in two steps. We say, what's the classification of these things? How do we do the classification? And then we talk about what are the rules that we apply. And I know everybody's itching to get to the rules, but I want to dwell for one more second on this question about classification. Do we think that this notion of an infrastructure layer or of infrastructure companies is a helpful or useful classification? So I guess that's one question I'd put out to the panel. Maybe we'll just start with that. Is this a useful classification? Does this help us get at dynamics that are happening that ought to be the subject of public policy? Or is this kind of incoherent and we see similar problems further up the stack, further down the stack? What do folks think about this classification of infrastructure layer? I'll throw that up as a jump ball. Hal, I see you off mute. Go for it, and then we'll go to Alissa.
All right. So I think it's okay to think about the different layers, but I'm not sure we need to impose different evidentiary requirements for complainants who believe that they are victims of self-preferencing at different layers of the stack. So let me just throw that out there as a thesis. So to review the bidding, I think we can all agree that the cable operators are on a completely different level of the stack than, say, Amazon or Apple. So I just want to talk very quickly about like what the evidentiary requirements are right now in the current non-discrimination regime that governs vertically integrated cable operators. And that is, if you bring a complaint, you have to show that your content is similarly situated to the cable operator's affiliate. Number two, you've received inferior treatment by virtue of your lack of affiliation as opposed to some legitimate business justification. And number three, as a result of 1 and 2, you were materially injured. Now, as I've been peddling this idea, this application of this non-discrimination regime applied to the application layer against the dominant tech platforms and the various app areas, I've thought long and hard about how would you change this evidentiary requirement that the FCC is using right now to police discriminatory conduct by vertically integrated cable operators. And I'm actually hard pressed to think about how I would go about changing it. I think it's really good and it's done well, offered protection. It's just hard for me to come up with a tweak to it. And so, as we move to a discrimination case against, say, Apple on the App Store, or against Amazon against a merchant, I don't know what I would do different from those three. And then I would just pose the question, if those three requirements are the ones that would work at that layer of the stack, why would we want to change the evidentiary standard to say we move down the stack and say some complainant who brings a case of discrimination against Amazon AWS? So I'll just leave it at that.
So maybe, and I promise we'll get to this discussion about what do we do about infrastructure providers? What rules do we impose? Maybe there's something about the nature of the rules that we might impose that says it's not worth drawing these sort of neat lines between the different layers. Alissa, what are your thoughts on this idea of the infrastructure layer? Is this a helpful construct or not?
So I think it very much depends on what you start with. So I think Hal made the point of it depends on what rules you're talking about. So he's talking about rules that apply to must carry. I think if you think about the difference of what you're looking at the platform layer, you're talking about often rules that are being applied very narrowly on particular pieces of content. So this goes back to Addie's point about the notion that you can take down an entire platform, and it's actually not that hard because you have a bunch of people who are sort of susceptible, who aren't used to a lot of public pressure because people don't know who they are, and are very susceptible to it generally. And so I think the reality of the effect is significantly different in taking down a particular post, for example, on a social media platform, to taking down an entire website or an entire platform. And so understanding that the proportionality component looks a lot different at the layer of whatever you want to call it, infrastructure or something else, is really important. So I would actually, if you went down to the telecoms piece, I would actually say it's more similar when you start talking about platform regulation or sort of what content is acceptable on a platform. It's more similar to doing something that looks like website blocking. So when is website blocking permissible? And less so cable must carry, and more that question of website blocking. When is that appropriate or not? And do you think that is the same? Do you think the same rules should apply for website blocking as should apply at the application layer for a particular post, or if there's sort of a requirement for liability, for example, on particular types of content? I think then it looks very different. So I think it very much, again, going back to the point that Hal made in the first place, depends what rules you're applying. But I think there are very different kinds of standards depending on what you're trying to get at.
So, Alissa, I heard in your response there, one thing we might consider is the kinds of consequences that might emerge. And I heard you say infrastructure providers might be differently situated from ISPs in one respect, which is that they're not necessarily these big companies. They're not necessarily used to public pressure. They are kind of behind the scenes. They're sort of business to business interaction. Sorry, I'm putting words in your mouth here, but on the other hand, the kind of harms that can emerge when discrimination occurs at the infrastructure layer can be fairly similar to the kinds of harms that we might see if an internet service provider were to flip the switch and block a website to all its customers or something like that. So it sounds like we see some similarities to the ISPs, some differences. Kate, Addie, any other thoughts on this classification? So is there an analogy that these infrastructure providers look more like the platforms at the application layer? Addie, you mentioned earlier thinking, kind of analogizing these to the content moderation debates that we have at the application layer. Do either of you see it differently, that we ought to be analogizing these things to the application layer?
I mean, I don't really have to think about this in a strict legal context, often the way that, say, Hal does. So for me, and often for readers, the sort of pragmatic question is, how hard is it to switch or to roll your own version of a thing? If you really have to host something yourself, that's something you can do. If something is built just directly into the structure of what is the internet, like a domain name, that's a lot harder to replace in a lot of ways. And I think that it's like a little bit of an easy answer, the like, well, if you don't like Facebook, you can go make your own Facebook or your own website. But for a lot of people, that's what matters, is how hard is it to find an alternative that isn't susceptible to the same kind of things that will make me unable to speak on a specific service.
So it sounds like another vote in favor of infrastructure as being, I think we heard in the first panel talking about essentiality are being critical to the experience of doing certain kinds of conduct online. Kate, any thoughts on that front before we move on?
Yeah, I mean, I think another way of saying what Adi just said is, does it exist and have market power that is enabled by government investment in infrastructure? And I think that that's one way to think of the difference between a broadband internet access service provider and kind of everything else. Though I agree that the application layer is different because it faces the user and they have a more granular ability to interact with users and with content. I do think that there is a difference between a broadband internet access service provider and everybody in between leading up to the application provider.
So it sounds like we've got some kind of mixed feelings about this conceptualization of the infrastructure layer. We've got some differences that we can observe. We can make some analogies up and down the stack. All right, so we've gotten several invitations to talk about the rules, and I think that's probably the heart of this conversation, is what sorts of rules might we apply here? So we discussed this morning in the context of net neutrality, a non-discrimination sort of regime, barring blocking for any reason, or maybe for other than legitimate technical reasons. And I suppose we might argue about what that looks like here. Hal, you referenced earlier in your comments the regime that we currently have for application layer providers, which is maybe not only laissez-faire, but affirmatively laissez-faire. With Section 230, we've actually encouraged discrimination and immunized discrimination, because that's something that Congress maybe said we want to see some of, at least 20 years ago when the Communications Act was amended. So let's talk about these different possible regimes, a sort of a non-discrimination regime, a sort of laissez-faire regime on the other end. Hal, I want to start with you, because you've obviously been a big proponent of bringing a non-discrimination regime further up the stack. Take us through what that looks like.
Yeah, well, I'm trying not to be very novel or creative here, but I'm just thinking about how we would apply it verbatim if we treat it the same way as we do these vertically integrated cable operators. And so, the burden of proof is on the complainant. They'd have a venue, they'd come before some tribunal. This tribunal could sit outside of an agency, it could sit inside of an agency. I'll note that in Senator Hawley's legislation that he put forward this week, he contemplates some kind of tribunal sitting inside of the FTC to regulate self-preferencing on search engines. And I think Representative Cicilline is going to come out with a non-discrimination regime of his own very shortly. Could be co-sponsored with Ken Buck, and in which case it would be bipartisan. But whether it sits inside of the FTC or outside of the FTC, the complainant would have a venue, and they say, "Look, I'm being discriminated against. The guy stole my idea, and then he disappeared me in search," and they would have three burdens that they would. I ticked off the evidentiary criteria, but if they could establish that those three criteria were satisfied, then they would get relief, and the relief would come in the form. I mean, again, if we're just being boring and we're just going to copy and paste what goes on in the FCC's tribunal, you get injunctive relief, which is the tribunal could say, knock it off, you can't discriminate anymore. And then you get monetary damages. Any profits that you could show that were lost and attributable to the discriminatory conduct, you get that back as well. I'm throwing in one extra twist. I don't know if anyone's going to go for it, but I said this in my House testimony. I'll say it again. But I think that you could also empower this tribunal to impose structural separation as a remedy as well. That is, if you had a recidivist discriminator who just keeps getting hauled in front of the tribunal over and over again, it's clear that they're flouting the law and they don't respect the non-discrimination regime, that the tribunal could order that a certain division be spun off. So, for example, if it were Amazon, I don't mean to pick on Amazon, I love those guys, but if they were there 5-6 times and it's just the same pattern over and over again, where they copy someone's idea and then they steer searches to their clone and disappear the originator of the idea in search, they would have to spin off the private label division. So that's how the regime would work. And I think what's interesting here is that if that were to become the law of the land, and I don't know what the probability is, it's just proposed legislation right now. The question is then, how would you alter that, if at all, as you try to extend it down the stack? And I just, in close, if I could say one thing to Alissa, that she said, when she said back what she thought I was saying, which was I was characterizing a non-discrimination regime. In cable land, it's so sad that we treat these differently, but we treat must carry as a separate animal from non-discrimination, but they're close. They came out of the same legislation. And I do understand why must carry might be a little closer to what you're concerned about, which is an obligation or duty to deal, with some other party. And whereas non-discrimination is that you don't have any obligation to deal with them, but if you're vertically integrated, you can't treat your affiliate any better than you treat the independent. One thing that's interesting is that cable operators can completely escape the non-discrimination regime simply by divesting from the content space. They haven't done that yet, but they could. The rules only hit vertically integrated cable operators. In contrast, the must carry provisions hit all cable operators. It only pertains to one very small kind of strand of content provider, which is, of course, broadcasters. I'll leave it at that.
Alissa, I heard some of that directed at you, so I might invite you in for a response on that.
Yeah, no, actually, that's really interesting. I think one of the challenges for us is that from a company standpoint, the areas that you're flagging on competition are not actually the areas where we see a lot of the public concern and, frankly, a lot of the congressional concern. So even though there are certainly areas related to the questions of vertical integration and non-discrimination provisions, for example, as an example, what we actually hear the concern about often is actually on the content side. So, which is something that I don't think that proposal necessarily addresses. So when we hear concern about particular content being online, why was this content not addressed? It is very much focused on the application side, which I think one of the challenges on the regulatory piece is if you're a legislator, you have to decide what problem you're trying to address. And so the challenge is that when people think about what platform regulation looks like, or just what regulation looks like in general, particularly at the application layer, they are thinking about different sets of problems. So you flagged a particular set of vertical integration challenge. There is a separate set of sort of problems online, toxicity online, illegal content online, problematic, things that are potentially First Amendment protected, but problematic for one reason or another. And so I think when we get into those conversations, we often hear it from that angle, not from the vertical integration or anti-discrimination piece in the way that it applies in the communication side. So I think in some ways it's sort of a challenge. It's, as you said in the beginning, it's sort of the definitional challenge of, what rules are we talking about? And then what problem are we trying to address? Because I don't think one set of regulatory structures necessarily answers them all.
So Hal, it seems like you're teeing up considering discrimination primarily through an economic lens, which I think we probably would agree is most of the debate that's happening at the network layer. And I've heard you in this conversation and others express those same concerns kind of through an economic lens about players at the application layer. It sounds like we have this class of infrastructural providers that maybe don't, it sounds like tell me if I'm hearing some agreement that I'm not, are not triggering those same set of economic concerns, but are instead implicating these kind of content moderation debates. Kate, can I invite you in on the content moderation front? I mean, it sounds like the example that you teed up in the beginning, Parler, certainly wasn't motivated about discrimination on economic grounds, right? It wasn't Amazon trying to kick Parler off because it was competing with Parler. It was something else, right?
Right. It's not my sense that Amazon Web Services wanted to offer a competing version of Parler. I don't think that's why it was taken down. I think it was taken down in response to public pressure about what happened on January 6th. And, I think that is the concern that Alissa was trying to get at. And one of the reasons that, deeper within the stack, we need stronger normative principles of neutrality, because there can't be, you don't want to have someone who can wake up one day, an executive at Amazon who can wake up one day and say, I just don't like what you're saying, and I am going to turn off your entire website, or I am going to turn off your entire service. And that is essentially kind of what happened to Parler, despite the fact that there was probably most of the content on the website probably was not, it was not in violation of any sort of law. And I think one of the things that we kind of need to remember is that when private companies have this kind of power, it can be turned against any single one of us at any given point. Like if we were in a different political moment, where the prevailing view was that trans children should not have access to healthcare, and there was some small website that provided information to families that had trans children where they were trying to get that information, but the version of Cloudflare or the version of AWS that hosted those services or provided protection from attack to those services received a bunch of public pressure from somebody like the President of the United States to take down or remove services from that site, we could be having a very different conversation. And there is nothing that prevents that from happening other than the political moment that we are in. And I feel like that is the thing that needs to be remembered as we're considering what the principles that should apply to these decisions should be going forward.
Okay, so let's shift over and talk a little and dig a little bit more into this content moderation debate. And Addie, want to invite you in here. So the version that Kate laid out is one version of kind of the argument that we're having at the application layer, which is we should be worried about these big companies discriminating on the basis of content because the exercise of political pressure might lead them to take things down and basically kick people off the internet. And we've heard in the conversation today, we might have some platforms here that are actually more susceptible to that kind of pressure because they're not as big as a Google or an Amazon or an Apple or what have you. But there's also another side to that debate, and Alissa, maybe you'll want to chime in on this as well, which is sometimes the infrastructural platforms might say, hey, we actually would like to have a say in what we host, and we might like to not be affiliated with neo-Nazis, or we might not want to be affiliated with the organization of violence online. Addie, I'm curious for your thoughts on that dynamic. That's a debate we're having at the application layer. How does it kind of filter down to the infrastructure layer?
Yeah, the problem is sort of that while I agree with a lot of the concerns that Kate has, I also have a little bit of trouble formulating a good legal framework by which you tell somebody like Amazon, which controls maybe 30%, I think, of roughly web hosting service. Like, it's not like it's literally the only way to get online. How you sort of tell it that, yes, you find this thing really distasteful, and yes, the people who run it are openly supporting something you hate, and yes, they refuse to do better, but you should be forced to host their speech. Like, that seems something that's difficult for me to come up with a good legal way to enforce, at least in the United States.
Can I be clear about something?
Yep.
I agree with 80. It is very, very hard. There are First Amendment interests at play here. I am not making the case that we can regulate these companies like we can regulate, say, a common carrier, like we could impose net neutrality principles in between the application layer and the clear broadband internet access infrastructure layer. Because I think that there are significant First Amendment concerns with that, exactly as you just raised. They have a First Amendment right, and First Amendment, there are speech issues on that side of things too. What I am saying is the normative principle from which we should operate, from which these companies should operate, should be a strong one in favor of neutrality because of the concerns of what would happen when we don't have it.
Yeah, I think we're basically at this point just like loudly agreeing that, yeah, it's really difficult to come up with a legal framework that matches necessarily the normative framework that we want companies to sort of socially operate under. And if you have a panel about governance, it's really hard to thread that needle often.
Yeah, one sec, Hal, because I heard Addie raise a point about dominance, and I do want to come back to that, and Hal, I may pick on you to do it, but I want to make sure we cash out this First Amendment point first. So, maybe a little bit ironically, I would think First Amendment scholars probably think folks at the application layer who are engaged in editorial discrimination as part of sort of the functionality of the platform might have very strong First Amendment rights. Folks down at the very bottom layer of the stack providing network access on what looks like maybe sort of a common carriage basis might have sort of the weakest set of First Amendment interests. Kate, I think I heard you kind of allude to that, but we've actually seen providers be a little bit different, or almost inverse of that when they're asserting those rights, right? We've seen the ISPs very vocally and in court assert First Amendment rights to discriminate on entirely economic grounds. And we've also seen in recent years the Googles and Facebooks of the world be a little bit reluctant to sort of throw their First Amendment interests on the table because they have a perception maybe that they want to maintain about being neutral, that asserting a First Amendment right might sort of complicate. So Kate, I heard you offer a provocation about where infrastructure providers kind of sit in that continuum. Alissa, Addie, Hal, I'd be curious for your reactions. Like, where do infrastructure providers sit in terms of both having and asserting those First Amendment rights to keep folks off the platform or decide what kind of speech they carry?
So I think from my angle, I think it's really interesting from a company perspective, because a lot of the challenges that we face are because of the way we've set up our company. So when we, so from a practical standpoint, as I mentioned in the beginning, Cloudflare is very unusual for the space that we're in, which is one of the reasons why we're one of the only providers who's talking about these issues, because we actually have a free service. So we are providing a set of free cybersecurity services to anybody who comes along. The challenge is that when you are in that world of providing a free set of services, the notion of somehow doing content moderation on First Amendment, your own, based on what you think is appropriate for the set of services, is almost it's just not tenable, frankly. So, we're a company of approximately 2,000 people. We have 25 million websites on us. The amount of traffic that sits behind us from a security standpoint is enormous. We couldn't, even if everybody in our entire company was in the business of content moderation, we couldn't do it. So from a practical standpoint, you have to recognize a little bit that those questions are in part sort of driven by how the company is set up. I think it's really different if you are a platform, for example. So imagine that you're a platform that's focused on a particular issue. So you're a platform that wants to just provide a place for discourse about crocheting, right? Like, you have a very specific mission. Your goal is to only talk about that, and you kick people off when they bring up other subjects. That looks a lot different, I think. And so I think some of those questions of First Amendment, we don't ground those the way we think about it as much in the First Amendment, but as the reality of what it actually looks like in practice.
Addie, invite you for any response on that, and then I want to turn to Hal on this dominance point.
As I'm pretty sure the only non-lawyer on this panel, I should not talk about the First Amendment as a sort of proactive protection for being refused to compel to speak. I feel like I don't want to muddle this.
I cannot imagine a debate over content moderation and the First Amendment being muddled in any way. Kate.
Can I just weigh in? Like that makes sense to me in terms of like how you would conceptualize it as a business. And I think from my perspective, the way I conceptualize it is what prevents the government from telling you how you can conceptualize it. And one of the things that prevents the government or can restrain the government, maybe not completely prevent, because I don't think the law here is fully developed, but one of the things that's going to significantly restrain the government from telling you how you can think about your business or how you can think about whether you can interact with or censor people on the basis of what they're saying or not, regardless of whether it's practical, is going to be the First Amendment, that there is some interest that you have, some level of expression that you are engaging in and deciding to design your corporation in the way that you have, and that you have chosen to host however many million websites and you aren't focused on crocheting. So that's kind of how, so I just think about it on the flip side, like what restrains the government from telling you how to do what you can do?
Completely agree. I think the other piece of that is that obviously when you get into the difference of thinking about infrastructure versus someone else, I think you also get into that question of scale. So I think that's one of the reasons why it becomes relevant, because so say the government tried to come up with a regulatory structure that sort of mandated that we take down and recognizing this First Amendment appropriate, but mandated that we take down a certain kind of unprotected. So let's find an unprotected content, incitement, right? That the likelihood of us being able to actually comply with that because of the nature of our services in the infrastructure is just completely different than it might be for someone at a different layer. And I think that's I guess the point I want to make. There's an alignment there a little bit that looks different.
Really quickly before we move on, sorry, I can't resist, Alissa. You're teeing into some discussions that we'll probably get into later today when we talk about the big application layer providers who sometimes embrace an argument along the lines of what you've just made, that we operate at such scale, you can't micromanage how we do content moderation. And then on the other hand, you have these immense governance efforts, things like the Facebook Oversight Board and so forth, that are aimed precisely at, setting up a structure for how we do content moderation. How do you think those arguments, the arguments you just make, do they play out differently at the application layer? Do they play out differently with those kind of companies? Or what's the, extrapolate a little bit if you want?
I do for some pretty significant reasons, and it's the reason that I would distinguish something like AWS, which I don't think is quite what we are, because we don't host. For the most part, we don't host from things that look more like platforms. So if you think about what most platforms do and what their business model is, they are looking for content, right? So they are trying to find particular kinds of content, to prioritize it, to advertise against it. There's a whole range of things that they do that's more in the sort of positioning of content. And so it's not that I think that they should be regulated on a particularly content specific way, but that makes them look different from an entity that is just sort of moving the content over, from a transit perspective, for example, or trying to make it more efficient. They are actually already they have their hands sort of in the content, trying to find what you're actually looking for if you're a search engine, or trying to give you something that looks a lot similar to what you're doing if you have an algorithm that's a preferencing algorithm, for example. So I do think that those things make the infrastructure layer look different than something that is specifically a platform.
All right,
Actually,
Hal, sorry, go ahead.
Oh, I was just going to say that I think that gets a little bit more complicated when you get into something like WhatsApp, where the goal is that it's an application and it's owned by like Facebook, which obviously is exactly the thing you're describing. But a lot of the point there is that it doesn't even see the content. And I think that messaging services are just a really weird sort of system, sort of their own.
Completely agree.
So we might flag for the conversation later this afternoon that we actually have got some differences at the application layer, similar to the types of differences we're discussing here that might be salient to policymaking there. All right, Hal, you've been patient. Let's talk about dominance. I promised that we would talk about dominance. I heard in Addie's answer that we need to have some consideration of the or maybe that we need to have some consideration of the role of dominance as we think about what kind of interventions to apply on these platforms. Take it away on that front.
Yeah, and her intuition, I mean, it was spot on, because when you think about what we're dancing around here is whether or not we should impose a duty to deal on providers in this layer of the stack, as we have on cable providers, in their dealings, we know, with broadcasters, as we had with telcos in the Communications Act, as we did going back in our common carrier panoply. We've imposed duties to deal, but I would submit that every time we've done so is to solve a communication distortion caused by a provider that was dominant in their domain. And so when I kind of look at the landscape here, and I see that Amazon AWS perhaps being the biggest with 30%, it's kind of on the edge of whether or not that even could be considered dominant. And so I would be loath to impose any obligation such as a duty to deal, which I consider to be on the range of invasiveness. I consider that to be kind of at the high end of government intervention. And I would be loath to impose such an obligation on any provider who was not clearly dominant in their domain. So I do think it's an important consideration, and it's probably what would prevent and hopefully immunize Cloudflare and any others from any such obligations. But that is, to answer Addie's question, how would we do it? We have the tool if we want to use it. I'm not suggesting we do, but the tool would be a duty to deal, which is that you basically you have to support all comers. And we've done that at other layers of the stack, but again, it's always been done on a provider who is dominant. And Blake, if I have 30 more seconds, I'll say one more thing about dominance. And if you want to cut me off, I could pass the baton too. Is that all right?
Please go ahead.
One thing that's kind of interesting is that I'm toggling back between our two tools, our duty to deal and our non-discrimination regime. And I just want to point out that we did not narrow the application of non-discrimination when we applied it to cable operators. We didn't say, oh, it's only going to apply to dominant. Right? We applied it to all vertically integrated cable operators, no matter how small they were. But in designing the evidentiary criteria, remember that third criteria was that the guy who was discriminated against has to prove they were materially injured as a result of the discrimination. We were effectively imposing a dominance requirement on the back end. So in other words, small vertically integrated cable operators are effectively immunized from the non-discrimination regime, because no independent programmer would ever be able to prevail on a court that by not being carried and I don't want to insult anyone's town, a small town in the Midwest, right? By not being carried there, we are materially
Nebraska
impaired.
is what you meant to say. Lincoln. Sorry.
Because Gus is still on. No. But right, it would be very hard to go into a court with a straight face and say, because we're not carried there, we are materially impaired in our ability to compete. So I just want to point out that you can ensure that the obligation doesn't touch the provider either on the front end by saying that we were only going to apply this obligation to dominant providers in their domain, or you can do it on the back end by kind of tucking it into the evidentiary criteria by saying that, if a complainant comes forward, if they can't show that they were discriminated against and it was done so on the basis of affiliation, and they were, as a result, materially impaired, that is another way to kind of make sure that the obligations don't touch the smaller providers.
So Kate, would love to hear your rebuttal on that. And one thing I thought I heard us say at the beginning of the hour is, and I wonder if this poses a difficulty for Hal's framework, is it sounded like when we were talking about the Daily Stormer and we were talking about Parler, that we have some pretty significant harm, right? I mean, from their perspective, getting booted off the internet for 30 days or maybe permanently, or maybe having to go deal with some registrar in Russia or whatever, it might be some kind of a significant harm. What are your thoughts on this dominance framework and whether that's a useful gating function here?
I'm not sure I have a rebuttal to Hal's framework. I'm less concerned by a requirement that says, you must take all comers or you cannot discriminate on the basis of viewpoint. But I also recognize that it is going to be difficult that there are going to be, First Amendment interests involved here for the companies themselves to some degree, where they're trying to make the decision based upon, the kind of content they are willing to host or willing to do business with. So I don't really have this all completely worked out. There were harms done to Parler, but a lot of those harms, at the end of the day, wound up being process harms, because they were able to find someplace else to be on the internet. So the question to me, in some ways, is, what are the proper standards that should be applied in the infrastructure layer or in the non-user facing layer to try to prevent those harms from happening, but still permit companies that are not necessarily dominant, like if we have a competitive marketplace, to be able to continue to do business with who they want to do business with and not do business with those that they don't want to do business with, to whatever degree possible. And I don't have a clear answer to this question. So I'm sorry if I'm disappointing everyone to some degree here. But I don't know. It is interesting because I wonder to what extent the framework that Hal offered would be able to function if dominance is required, and we're not really sure whether there is anybody that is dominant in this space.
Well, on that note, so I have so many more questions that I want to ask, but I have promised in our agenda that now is the time that we will turn to Q&A from the audience. So if folks have questions and want to throw them into the Q&A using the little Q&A button at the bottom of your screen, I am delighted, as always at Silicon Flatirons, the first question goes to a student, and one of my very best students from the last 3 years who's about to graduate, but has done a lot of really interesting work on this stuff. Connor, please jump in.
Thanks, Blake. I'm sure your questions would have been better than mine, but I'll throw what I have. So Nick Nugent just published a paper arguing that despite the contractual rights that DNS intermediaries reserve for themselves, domain name registrants should be able to state claims under conversion and trespass to chattels when DNS intermediaries seize a legally operated domain name without a court order. So I'd love to hear your thoughts on that specific idea, but more broadly, when you think about governance tools, do you have thoughts on the pros and cons of a tailor-made statutory scheme like the Cable Act versus a rights-based regime grounded in common law or constitutional rights like property or the First Amendment?
jump ball for the panel, and while folks summon their thoughts, I'll just say this is going to be a theme that's going to come up hugely in the next panel as we talk about private alternatives that have arisen to Section 512 of the DMCA. So if we impose rules here, if we impose a regime in the space, what are the possibilities that other doctrines like contract law or perhaps property law or something else might intervene and do some private ordering here? Any thoughts, Alissa?
So on the DNS question, I'll start with that one. I think it's an interesting question for a couple of different reasons. I think what you will find is that there are more formal mechanisms to address seizing of a domain name, for example. So a lot of them actually come contractually, which means that there'd be an interesting thing to potentially challenge. But there are generally, when you sign up for DNS, when you sign a registration agreement, you actually submit to a set of contractual requirements, some of which are sort of relate to the seizing of a domain name. Those are not the same as law enforcement ones. They tend to be on the IP access side, but they are standard form for most registries because they're governed by ICANN. So ICANN has their sort of own set of contracts that then apply across the board. So it ends up in a matter of contract as opposed to a matter of property necessarily. It might be an interesting area to think about how you would challenge a contract from a legal standpoint, but it is actually done primarily by contract. And then to the extent that there is seizure of domains otherwise, it actually, in my experience at least, we do actually operate a registrar. It is actually done by, it is done with court order. So it is, it's not, it doesn't seem as far out there as you might think.
Hal, I see you off mute. Is that just an artifact, or did you have thoughts on that one?
I don't know. I think I'm going to let that one go. I have feelings, but we'll keep going. I don't keep going.
Okay.
Thank you.
I see in the chat we're going to have a question coming into the Q&A from another student, a current student, Scott Goodstein, and thanks for the question, Connor. So Scott asks, regarding content moderation at the AWS Cloudflare level, should there be a different set of rules between normal harmful communications, normals in quotes, and harmful advertisements? I'm thinking specifically about dark patterns where advertisements are intentionally deceptive or manipulative. So obviously that's a big component of the content moderation debate at the application layer. Any thoughts for folks on advertising and how that plays into the mix? And jump ball for the panel.
It seems like sort of the issue for that is that, as far as I know, we don't have particularly good laws around it at all. Like, there's a pretty open discussion about whether the FTC should be stepping in to regulate stuff like dark patterns. There have been some bills that weren't necessarily amazing, but addressed it. And it seems like at that point, once there's any kind of legal framework, then the question becomes, is there a kind of liability for the intermediaries that are maybe hosting this stuff?
Yeah, so echoing a point we heard earlier that, we, and Hal, I think you raised this, we just don't have settled law at the application layer about this sort of stuff. In your view, how is that going to take more development there before we sort of see answers on this at the infrastructure layer?
Yeah, and it's interesting to watch. Maybe this is an answer to Connor's question, but I think it was how do we expect this to come about? And we've only seen one taste. I think Hawley is the first that I'm aware of, and he would amend the FTC Act to define unfair to include self-preferencing in search. And I think that he would have these cases adjudicated, as I'm reading the legislation, on a case-by-case basis inside the FTC, perhaps at some tribunal. And to me, and I think the question was, should we use the Cable Act as a template? What I'm kind of waiting for, and I have no idea how it's going to shape up, is the way that Ciceline's bill is going to look when he makes a run at non-discrimination. So we'll see if it also amends the FTC Act, if it's something else. But that is about as much of a concrete answer as you're going to get from an economist. They don't come to me for how to do the drafting, just the ideas.
Well, on that front, maybe we can riff for our last 3 minutes here. I know I promised there would be a third tent pole to this conversation, which is the political economy of all this stuff. Alissa, I saw you coming off of mute there, so please feel free to chime in, and if you want to go a different direction, that's okay. And then closing thoughts from anybody on the political economy of reform in this space with any of the legislative discussions that are happening right now.
So I was actually going to answer the advertising question. So I was definitely going in a different direction. But I was just going to say one part I didn't include in my sort of taxonomy is the way advertising actually follows you around online. So a lot of it would depend where the advertising was coming from. You know, we as a company, we don't do advertising. That's not our business. We don't actually enable people to target from an advertising standpoint. So it's really not us. There are the way things get, the way advertising actually works is a little bit different. Some of it's sort of very much at the application layer, and then some is there's a whole range of things that come up with cookies and a whole bunch of other things that get more technical. But yeah, so that was all I was going to say on the political economy question. I think I should defer to others.
Well, real quick, Alissa, to your answer there, that just provoked me to think, in all of the years of the net neutrality debates, I don't think we ever have heard of or thought of or heard the reactions of ISPs about the notion of having to do some kind of filtering or being mandated to do some kind of filtering, except maybe thinking about copyright. So thinking about that advertising dynamic for someone that doesn't necessarily like to do a lot of discrimination. It's kind of interesting to hear that question crawling down the stack a little bit. So I see we're right at time, but I want to throw it open to Kate and Addie for any last minute reactions on any of the above, and then we'll close it out.
Do we think app stores are infrastructure? That's a thing that I think we didn't really get to.
Hal, 5-second answer.
I'm not allowed to talk about app stores anymore. But can I say one thing about political economy? Adi, did you want to say something on that though? I can shut up, and if you were going to go off on app stores. Can I say one thing? With Justice Thomas's statement last week, where he basically was saying that big tech should be treated like common carrier. I'm paraphrasing, but of course that would include certain duties, duty to deal perhaps, or non-discrimination. There is a weird thing going on the right among conservatives, where I feel like they've got a different take or approach now to these sorts of obligations. So it's hard for me to predict how these ideas are going to develop. But if you would have asked me the same question about a year ago, I would have given you a different answer. It seems like there could actually be some kind of bipartisan movement, at least on the app layer, in terms of non-discrimination.
Kate, any closing reactions on that one?
No, other than to say I agree that the effect of Justice Thomas's opinion has been contrary to some of the previous thought that I had seen happening. I'm not quite sure that we're going to see agreement as a result of that, because I'm not quite sure that folks agree with Justice Thomas that application layer services should be neutral in that way. I think that there are a lot of folks that want to see more moderation. I'm not saying that the ACLU is among them, but it's one of the reasons that I think politically we're still pretty far away from agreement, even at the application layer.
Well, that is a perfect note on which to end it. I hope you will join me virtually in saying thank you so much to all of our panelists for a really rich and terrific discussion. This is a topic that's been percolating for me for the last 2 or 3 years, and I'm just so delighted that we got to hash it out for the last little bit. And so thank you all so much for your contributions here.